Okay, people, we're getting some very interesting news out of Los Angeles, okay, out of California. It looks like Lil Durk's team, his legal team, is riding hard for Durk. They're trying to bring Durk home, and they've just filed two motions back to back, which some people actually think might end up bringing Lil Durk home on a crazy technicality. Okay, so I'm going to break down these two motions for you guys and give you guys a full understanding of everything that's going on in these new bits of paperwork that have come out. And it seems like Lil Durk's lawyer, Drew Findling, is going hard for his client. They're digging deep into some historical legal precedent, and they're trying to bring Durk home. They're trying to get Durk off scot-free, man. So this is a motion that was filed, okay? Shout out to Durk all day, and shout out to Seti Nash, who let me know that this paperwork existed. But this is some new paperwork that's been filed. And before we get into it, I just want to point out one very interesting detail, okay? At the top of this motion, we've got information for all of Durk's attorneys in all the different cities that he's active, okay? You got the head honcho, Drew Findling, Marissa Goldberg from the Findling Law Firm. That's in Atlanta, Georgia. You got Jonathan Brayman from Breen and Pooh in Chicago, Illinois. That's Durk's home city. And you got Christy O'Connor from the law office of Christy O'Connor in Los Angeles, California. There's a name missing, isn't there? I ain't seeing no Brian Steele there. So as you might have seen in my previous video, Young Thug is running around saying that he paid for Durk's lawyer and that he sent Brian Steele out to try and get Durk out. We're not seeing no Brian Steele. And we saw that Lil Durk's wife, India, posted a cap emoji after Thug basically went on his interview and said that he'd sent the money for Durk's lawyer, saying cap. And it looks like that is indeed cap, because there ain't no Brian Steele on here. He's not working the case. He's not on the motions. Who knows? I mean, you know, maybe he's out. Maybe he's on the team getting drinks and snacks for Drew Findling, the big dog. But realistically, it does seem like that's cap. I ain't seeing no Brian Steele on here. So it sounds like Young Thug is indeed lying about him sending Brian Steele to be on the case for Durk, because his name is notably absent. So that is sounding like indeed a whole bunch of cap. But what's really interesting about this, there's two motions. This is the first motion. And in this one, they're filing a motion to dismiss the indictment due to vagueness so the defendant Durk Banks is filing a motion to dismiss for vagueness, or in the alternative for a bill of particulars. So they're basically saying all of the stuff that you're saying that I did, you're being too vague. You're not being specific about how it happened. And I'll get to exactly what they're talking about in a minute. They're saying either throw it out or tell us the particulars, tell us more information, give us discovery, give us information and background on the actual, what you're actually saying that Durk did, because you're being too vague, okay? Now, there's a little summary that came with this, so I'll read that. I think this will just give you a very expedited version of what's going on, and then we'll get into the meat and potatoes of this motion and actually what's being requested. It says, this is a motion filed by Durk Banks' attorneys to dismiss the second superseding indictment due to vagueness, or in the alternative for a bill of particulars. There's a hearing for this motion scheduled for November the 18th, 2025. So it's going to be over a month before this is even seen by the judge on his desk. It says the motion basically argues that the indictment is impermissibly vague because it lacks specific details regarding the bounty that Durk allegedly offered for Quando Rondo's murder, and at the discretion of language used to describe his alleged involvement in the co-conspirators' actions. The attorneys contend that without these specific, Mr. Banks cannot adequately prepare his defense, prevent surprise at trial, or protect against double jeopardy, okay? And it says the key points of the motion include, I don't know if this is a ChatGPT summary or if somebody's actually worked this out themselves, but it says vagueness of bounty allegations. The indictment alleges that Mr. Banks used coded language to offer a pecuniary bounty, money, or lucrative music opportunities with OTF for Quando Rondo's murder, but it doesn't specify the language used, when, where, or how it was conveyed, or the exact nature of the reward. So it's saying that, look, that original superseding indictment, okay, it was the second indictment. They upgraded the indictment with more information, and they also took out some of the lyrics. They're saying that the state is saying that Lil Durk put up a bounty for Quando Rondo's murder. He used coded language, and that he was offering music opportunities or money to basically entice OTF members to go and kill Quando Rondo, and they did that, and they ended up killing his cousin Lil Pap. The state hasn't let the defense know what this offering was. What was the coded language? You're saying coded language. Well, what coded language? What did he say? Did he say, hey man, if you know what I'm saying, if you slide for Von, you're gonna get some features, twin? Or did he say, you know, hey, if you put two on the scoreboards, you finna get a big bucket. Like, what is this vague coded language? They want to know what was actually said so that they can pick it apart and try and put together a bulletproof legal defense of it. Okay, they don't actually know what's been alleged. It could be iCloud messages, it could be recorded conversations, it could be a tapped phone call. We don't know what it is that Lil Durk actually said in coded language to offer up this mysterious bounty to have Quando Rondo killed. It also says vagueness of at the discretion of allegations. The indictment states that the co-conspirators acted at the discretion of Lil Durk in traveling to LA, tracking, stalking, and attempting to kill Quando Rondo and procuring firearms, but it fails to provide specifics on when, where, how, and to whom these directions were given. Again, they're saying it's vague. They're saying, you're saying that these guys did this at the direction of Lil Durk. How? How were they at the direction of Lil Durk? Be specific. When and where and how and who was actually giving these directions? When did Durk tell the guys to slide for Von? Who did he tell to slide and then they passed the information down to actually get the shooters? Where were they? Was this on the phone? Was this in person? Did he write it on a bit of paper and read it and set it on fire like those guys from Prison Break? We don't know. So they're trying to find out exactly what the state have, and the state said they had a whole lot of evidence, but we haven't seen it yet. And then it also claims that there's constitutional and procedural violations. It said this motion argues that the lack of specificity violates Mr. Banks' rights under the 5th and 6th Amendments and Federal Rule of Criminal Procedure, which requires a plain, concise, and definite written statement of the essential facts constituting the offense charges. So Durk's lawyers are basically saying, you're violating my constitutional rights. I have the right to plain, concise, written statements of the facts, and you've not given this. He's saying that the state is keeping things top secret. They're not letting people know exactly what was said, where it was said, and all of that stuff. And then this says, dangers of a vague indictment. The attorneys highlight 4 dangers: inability to prepare an adequate defense, risk of being tried for an unindicted offense, government shifting its legal theory, and deprivation of protection against double jeopardy. So they're basically saying, look, this isn't fair. We're not able to create a legal defense. We're not able to defend ourselves against these allegations because you're just saying that Durk directed this. You're not showing it to us, and you're going to blindside us at court. Okay, we're going to have no way to prepare for this. We're not going to have an adequate defense. You're trying us for unindicted offenses, things that we didn't even know that Durk did. You're saying that he did things, but we don't know. So they're basically saying you need to either throw this out or tell us what's going on. When it comes to their request for information, it says here, the request for bill of particulars. As an alternative to dismissal, if you're not going to throw the whole thing out, flush it down the toilet because it's unconstitutional, at least the motion requests a bill of particulars under Federal Rule of Criminal Procedure to obtain the following information: the language that Durk allegedly used to convey the bounty offer, the nature of the pecuniary value offered or delivered, was it a monetary reward or was it a music opportunity, how did that look, the date, time, audience, and circumstances of the alleged bounty offer, and the language used, the date, time, and audience and circumstances related to the at the discretion of allegations. They're basically saying, you got to tell us how Durk directed these guys, what he offered. You have to make it very clear to us what we're even defending ourselves against. So I think this is a really interesting development, and this is basically it's a whole legal document that goes into a bunch of case law, other cases where they feel like are actually in support of what they're saying. Okay, and I'll pick out a few really interesting parts of this and share them with you. So here at the very start, it says this indictment is impermissibly vague. It leaves the defense to guess at the government's theory of guilt, and it leaves the government free to change that theory as its cooperators' stories morph over time to meet the demands of a conviction. Because the indictment omits factual particulars necessary to give Mr. Banks notice of the charges against him and for him to permit his defense at trial, it fails to satisfy these sections of the Constitution, the 5th and 6th Amendments. Dismissal is warranted. As an alternative, we seek a bill of particulars. So they're saying that, look, the way that you guys are doing this and you're keeping things very vague and you're not telling us exactly what Durk did to direct these guys, the government are free to change their theory. I mean, they took out the musical lyrics, right? When Durk's team used very questionable evidence, in my opinion, to basically try and prove that this song that was released after the murder, that referenced the murder specifically, was recorded before the murder. The state said, yeah, bet, we'll take it out. We don't need them lyrics. We don't even need that, all right? We got other stuff. But we don't know what that other stuff is. So they're taking stuff away. They're removing songs from the indictment, but they're not saying we got a wiretapped conversation where Durk's saying he's got 10,000, he got a 10 pack for anybody from NBA Youngboys camp. We're not knowing what that is. So they're basically saying we need to dismiss it on that basis. This section here, it says counts 1 and 2 allege that Durk conspired and participated in murder for hire, and a murder in consideration or the receipt of a promise or agreement to pay anything of value, or what the government calls a bounty. So they're basically saying, you need to tell us, what is it, all right? What was actually offered? Was it a song? They mentioned about music opportunities. Was it money? It says here, the problems with count 1 and 2 is that while they do allege that in general terms, Durk offered a bounty for Quando's murder, they don't provide the specifics for him to prepare his defense. He's going to get surprised at trial. They're saying that, Durk just used coded language that oxymoronically made clear that TB's killer would be provided with money or lucrative music opportunities with OTF. But according to the government, what was the coded language he used? The grand jury's seen it. Where and how was this coded language conveyed? What was offered? They want to know what was offered. They want to basically work it out. And as I just said, it's the same with this discretion of, how do you guys know that these guys were doing this under Durk's orders? We need to know. They don't even know. Okay. And they're quoting a lot of stuff from the original indictment here. They've got specific quotes from the allegations that are made at Durk. It says here, at the discretion of Durk, defendant Grant would procure cars, ski masks, and firearms that would be used to find, track, and kill Quando Rondo. And they're saying, well, how are you proving that? Tell us how it's at the discretion of Durk. Where's the conversation or the recording or the messages that prove that Grant was procuring guns and ski masks and firearms to kill Quando Rondo at the discretion of Lil Durk? Now, look, this doesn't necessarily mean that he's going to be in the clear and they're not going to be able to prove that. But what it does mean is that at some point, once this actually goes to court in about a month's time, the state either are going to have to abandon the case, which I'll be honest, I think that's a very, very unlikely thing to happen, or more than likely within a month, we're actually going to see the state providing, text messages, recorded conversations, potentially whatever it might be, to actually show how they think that Lil Durk actually organized this whole thing. And it is going to be crazy. Okay. Now, there's been reports that this case has been sealed, that the public aren't going to be able to find out some of this information. Now, I wouldn't be surprised if some of this came out publicly. This is a public filing. There are specific informations that are in this case that are being used, kept under wraps to protect defendants, their identities, their locations, their addresses, their cooperation, all of that stuff. But I feel like because this is going to trial, we are eventually going to find out exactly what it is the state say that Lil Durk did to set this whole thing into motion. And so this later part is quite heated, and it kind of really clears the way for Durk to make a pretty good defense of himself. Okay, so this is a section where they're basically pointing at the argument of the supposed bounty and the direction. It's saying what the indictment fails to tell us are the very things the defense is entitled to know, the operative facts underlying the government's theories of Durk's guilt. There is no allegation here that Durk physically participated in the stalking and shooting at issue. All right? The entirety even of the government's case then is first that he somehow offered and paid some sort of unspecified bounty in exchange for the murder, and second that he directed in some unspecified way the stalking, the firearm possession of the murder, and perhaps also the bounty's payment. Those are the only two links, all right? They're saying that the bounty and Durk's direction of others are the only thing connecting him to the crimes. Now, look, I've said it before. I thought it was a bit of a smoking gun that Durk was in Los Angeles when this all went down. I was absolutely blown away. As somebody that's followed this closely, I never would have expected Lil Durk would be dumb enough to be in Los Angeles while this is happening. Oh, no, it's dumb. I'm just going to keep it real. It's dumb. If you're actually going to do this, why the hell would you be in the city? Yeah, I'm going to have somebody killed and I'm just going to be there in the city nearby while it's all happening. I don't live in that city. This is going to be one of the wildest things that's going to be going on in the hip-hop drill music history ever. This is one of the wildest things that's ever happened nationwide when it comes to this drill stuff. Why would you be in the city? But as his lawyers are pointing out, what are you actually? They haven't presented any actual factual information at this stage to prove that Lil Durk was calling the shots in this situation. And so here they go into a little bit more detail about what is the supposed reward that was put up for the murder. And it basically says the same holds true for the nature of the pecuniary consideration or financial consideration that Durk supposedly offered or gave. The indictment avers that the murder was undertaken as consideration for the receipt of and consideration for a promise and agreement to pay anything of pecuniary value, namely money and lucrative music opportunities with OTF. But then they don't know what sum of money is alleged to have been offered as a bounty. Was it paid in cash? Was it paid in wire transfer or a written check? What were these lucrative music opportunities that served for the alleged consideration for Quando's the attempt to murder Quando, which resulted in the death of his cousin. Was it a feature on one of Mr. Banks's songs that the government claims was offered and furnished in consideration of the murder? If so, which song? The defense is titled to know. Now, I'm no big city lawyer, but if you ask me, all right, I'm just going to guess. This is just a guess in my personal opinion, but I feel like the state, all right, they're going to hit them back with Loyal Bros 2. I made a video previously, okay, when this whole indictment dropped, that say that this album is one of the biggest self-snitches in the rap game history, because it really does have a whole bunch of lyrics that appear to refer to the murder, all right, all of these little hidden diss songs, and there's a whole bunch of OTF members on here that is kind of, I don't know, it's a little bit suspicious. Some of the people on here, man. Some of the people on here, I don't know, man. D-Ski. All right, that's OTF Didi. He wrapped up in the whole situation. Okay, you got OTF Jam, Ironic, the Federal Freestyle. Okay, Durk got a couple people on here who I don't know. Who knows if this is what it is? People might say, "Hey, Didi, he arranged for all that stuff to happen, and you gave him a hit. You gave him a hit song. He gave you a hit in the streets. Could be the block is hot." The feds might actually clap back and say that. Okay, so in my opinion, this is the sort of thing that we're going to see them clap back with. They're going to say, well, he was on this project. This was only a few months after the murder. And it was basically a victory lap album. It's got a whole bunch of disses. It's got a whole bunch of lyrics that appear to be referring to the incident. And they're going at them. Okay, we did it. They know that we did it. Bro. And he got King Von on the song. It's very, very incriminating if you ask me. So I think this is what they're going to end up bringing up at the trial, frankly. So they offer up a whole bunch of case law. I'm not going to read the whole thing. It is kind of interesting, but there's quite a lot to it, and it's in very legalese kind of terms. But it basically says the indictment should be dismissed as vague, okay? They're basically saying that, look, if you can't provide us any of this stuff, if you can't prove us with any of this stuff, okay, you're going to have to dismiss this thing, all right? They're saying that this indictment creates a risk that Durk will be tried based on conduct other than the conduct that the grand jury found when it returned the indictment, okay? And what's really interested in is they're basically saying the defense must guess what aspects of Mr. Durk's interaction with purported co-conspirators happened during the time period between or before November 6, 2020, which is King Von's murder. It actually wasn't a murder. They shouldn't call it a murder. It was a lawful killing. Sorry if anybody's offended by that, but it wasn't a murder, so that's disingenuous. And August the 22nd when the actual issue happened, okay? So they're basically saying, look, they're basically trying to put this on Durk. It's not fair. There's not being specific enough. If you can't prove it, if you can't come back with some text messages, some songs, maybe a little couple Loyal Bros 2, couple of choice songs from this project, then you're going to have to throw this thing out. But it is a long shot. But interestingly, in addition to this filing, they've actually made another filing that actually might have more legs. It might be a little bit more political, but this is another full indictment that's essentially aiming to dismiss the entire case. And again, this has got a very interesting backstory to it that I'm going to break down for you now. So this is the other motion that was filed. Okay, this is a motion to dismiss the entirely, completely, and to disqualify it based on the unlawful designation of Bilal A. Essaili as the U.S. Attorney for the Central District of California. Now, this summary, I'm guessing this is like a Google AI summary, but it's actually quite helpful. I think this is quite interesting. But it basically says, this legal document is a motion filed by attorneys for Durk Banks requesting the court dismiss his indictment and disqualify Bilal A. Essaili from serving as a U.S. attorney for the Central District of California. They're basically arguing that an unlawful designation has taken place, and it claims that Bilal A. How do I say that name properly? Bilal Essaili's designation as U.S. Attorney for the Central District of California violates the Appointments Clause of the U.S. Constitution because he was never confirmed by the Senate. It details how Essaili was initially appointed on an interim basis, and when the 120-day term expired, the Attorney General used a trick to designate him as the acting U.S. Attorney by first appointing him as a special attorney and then as a first assistant U.S. Attorney. They're basically saying that this violates the laws, okay? His continued service violates the law governing U.S. attorney vacancies, the Federal Vacancies Reform Act, as he doesn't meet the criteria for an acting officer and his 120-day interim clock has expired. They also claim a funding violation. It asserts that funding for Essaili's office violates the Appropriations Clause of the U.S. Constitution because public funds are being spent unlawfully by an appointed individual. And what's really interesting about this one is this basically outright requests the dismissal of the indictment against Durk completely with prejudice, or alternatively without prejudice, and the disqualification of Essaili and any attorneys under his supervision for participating in the prosecution. Okay. So let me just give you a little backstory on this gentleman, okay? So this is the acting U.S. attorney for the Central District of California that's overseeing this case, right? Bilal A. Asaili. I hope I'm saying that right, Asaili. And it says Bilal A, aka Bill Asaili, is the acting U.S. state's attorney for the Central District of California. In this role, he leads a team of 500 lawyers, special agents, and staff members enforcing federal criminal law and safeguarding the approximately 20 million people living in the largest district in the country. Mr. Asaili served as a federal prosecutor in the office's LA and Riverside offices from October 2014 to February 2018, and in this role, he prosecuted criminals charged with violent and organized crime, bank fraud, securities fraud, and other white-collar criminal matters. Mr. Asaili was part of the team of federal prosecutors that responded to the T attack in the Inland Regional Center in San Bernardino in December 2015. He also obtained a conviction in August 2015 at the conclusion of a 3-week criminal trial of a Santa Barbara doctor charged with unlawfully prescribing opiates, which resulted in the death of more than a dozen patients. For 2 years prior to serving as a federal prosecutor, Mr. Asaili served as a deputy district attorney in the Riverside County District Attorney's Office. He also worked in private practice for several years. I just seen something, man. This is gonna make you laugh, okay? Mr. Asaili also served in the California State Assembly representing the 63rd districts, man. He from 63rd. He from 63rd, so you know he trying to get Durk out the way, man. He really from the 63rd district. That's crazy. I can't believe what I'm reading, man. Now, he really from 63rd. Okay, so you know he wants to get Durk out the way, man. You know he wants to get justice for Durk and all of that stuff, man. It's comprised of a portion of Riverside County and also diversity, man. He's the son of Lebanese immigrants, the alumnus of Centennial High School in Corona, California, State Polytechnic University in Pomona. All right, he chilling with whacking them, and Chapman University School of Law. Okay, so he's a serious guy. But people are calling into doubt his credentials. They're saying that the way that he was appointed wasn't proper, and that they're basically now saying, look, we want to get this whole thing thrown out because the way that you appointed him is not right. It's unlawful designation as the U.S. attorney. Okay, he was an interim. He was meant to be there in an interim position for 120 days. He's saying that they pulled some maneuvers behind the scenes to get him to hold down that position long term, and he shouldn't be. And they're trying to say, hey, this fool from 63rd, he handling this all wrong. We need to get him out of here, man. We need to get Durk out. We need to free Durk. This whole prosecution is unlawful because of the position that he's in. So I'm going to give you some interesting backstory on this guy. And I think it's pretty unlikely that this is going to work. This is kind of a Hail Mary approach. But when you learn some of the backstory about how he got appointed, now look, I'm not casting any doubt on his appointment, but it seems like the way that he was appointed maybe didn't follow the usual processes. And if that is the case, the way that they're making this filing is a Hail Mary, but you never know, it might actually work. They might be able to say, well, the way that the appointment happened, it wasn't quite. So they're basically saying the designation of Bilal Asaili to the U.S. attorney violates the appointments clause of the U.S. Constitution. It does not permit the attorney general to appoint without Senate confirmation a private citizen and a like-minded political ally to wield the prosecutorial power of the United States. The same Mr. Asaili lacks the authority to conduct the prosecution, which can be taken only by someone lawfully appointed as a federal officer. Because he's not lawfully appointed, allowing Mr. Asaili and the prosecutors he supervises to continue federal spending in furtherance of this prosecution also violates the Appropriations Clause, which prohibits the payment of Treasury money unless it's been appropriated by an act of Congress. Okay, now let me give you some more backstory on this guy because I think this is quite interesting. Okay, this is Wikipedia, and it basically explains how he was he's currently serving as the United States Attorney for the Central District of California, having been appointed to the acting position in July 2025, having previously been appointed to the interim position in April 2025. And apparently that's not the normal way that you go about this. So this is going to be some backstory on how he ended up being appointed, okay? This says in April 2025, U.S. Attorney General Pam Bondi appointed him as the interim U.S. Attorney for the Central District of California. The appointment was made under federal law, allowing the Attorney General to fill vacancies without Senate confirmation, but just for up to 180 days. The district, headquartered in Los Angeles, encompasses 7 counties and nearly 20 million residents, making it the largest federal judicial district. His appointment prompted pushback from Democrat officials and progressive organizations, culminating in the launch of the Stop Asaili campaign, a grassroots effort opposing his confirmation on grounds of alleged political retaliation and civil rights concerns. Now, there's a whole campaign, and this is the website, okay? This is the, man, they want the big racks, man. What the hell? They want that bread. Hell no. Anyway, it says, stop Asalee, protect children, and defend democracy. They're saying Bill Asalee, as the U.S. Attorney for the Central District of California, poses a clear and present danger to the LGBTQ plus youth, immigrant communities, our environment, labor leaders, and the impartial administration of justice. They're saying since being appointed, he's weaponized the office for political gain, overturned a jury conviction of a sheriff deputy found guilty of excessive force, targeting SEIU California President David Huerta for standing with workers, appearing to direct FBI agents to tackle Senator Padilla, and threatening local officials in Santa Ana with criminal prosecution for protecting immigrant communities. As Speaker Rivas puts it, his abuse of position is the mark of a small and petty man. Asalee was powerless in the assembly, and he's using his Trump-bestowed job to settle scores, okay? They're saying that he's out of control. Here's a small sampling of his recent threats against the community. Now, look, I'm not trying to get political. I'm not for or against any of what's going on, okay? I'm just pointing out, okay? This guy's getting busy on Twitter. They're saying that he's blocking regulators from enforcing, reducing pollution in the environment, threatening criminal charges against public servants. You know, he's getting busy out there, basically, okay? I'm not seeing anything about Lil Durk. I don't know if this campaign's really going to want to keep people like Lil Durk on the street, but they're basically livid about this whole situation. So here's an article on how controversial the appointment was when it happens, right? It says I can't talk today, man. What the hell? Trump administration maneuvers to keep Asalee as LA's top federal prosecutor. It says the Trump administration has taken unusual steps to allow Bill Asalee to remain as the U.S. Attorney for the Central District of California without confirmation by the Senate or appointment by a panel of federal judges. Okay, this is apparently Trump administration's latest maneuver to define norms and keep controversial appointees in positions across the country. And Asalee is apparently a staunch conservative and a Trump ally. He was named as the new district attorney, okay, and he was basically be sworn in and granted the title. People are saying the maneuver echoes steps the Trump administration took to keep its chosen prosecutors in power in New York, New Jersey, and Nevada in recent weeks, allows Asalee to stay in office while sidestepping the normal confirmation processes in the Senate. He was appointed by Pam Bondi in early April. They must be confirmed by the Senate within 120 days, but Trump never moved to formally nominate him, where he would have had fierce opposition from the other senators in California, basically. So apparently his fate was left in the hands of a local federal judicial panel, which declined to name anyone to the post. And essentially, he assumes the role and he gets another 210 days in the position before he has to face any confirmation processes. And essentially, the U.S. Attorney's Office has referred the questions to the White House. And basically, he's a smooth character, man. He basically said, look, they asked him about it. They said, when do you think your term might end? He said, we got some tricks up our sleeves, man. Hey, we from 63rd, man. We got some tricks up our sleeve, man. We working to get these fools out of here. So look. All right, they're saying Trump's administration is willing to use legal workarounds to keep its appointees. Now, look, we're getting a little bit political now. I don't know if you're really here for political content, but this Durk situation has realistically gotten incredibly political, okay? And this paperwork, it really has taken this big hot button issue that's going on politically. They're casting doubt over the district attorney for the Central District of California. It's a long shot, but you never know. Lil Durk actually might get out on political reasons. It is possible. There's a small possibility. They're calling for the whole thing to be wiped out. If I'm completely honest, I feel like stuff like this, look, this isn't necessarily going to get Lil Durk out here anytime soon, right? If this actually is successful, they're really going up against the US government. They're really going against Donald Trump. They're going against the whole political administration that's in power right now. And that's something, if you're actually going to take this avenue and have this go well, this is going to take years. Right, you're more likely taking it to trial and trying to beat it on the evidence than you are at toppling the whole district attorney and going after Trump when he's got the game on lock right now. Okay, that's all I'm going to say. I don't want to get too political, but Trump got the whole thing on locker. Okay, there ain't really much anybody can do to if he wants to make this happen. He's gonna make it happen. He's gonna find a workaround. As the guy said, he's got some tricks up his sleeve. But this is the latest in the whole Lil Durk situation. He's taking things right to the top. He's taking things to the political level, and he's saying, look. You need to show the evidence, how I actually organized this thing and orchestrated this thing and allegedly paid for this thing. And if you can't, you got to throw this thing out. And they're throwing a Hail Mary and going political and basically saying, look, this guy shouldn't even be able to, he shouldn't even be in the position, he shouldn't even have the budget to prosecute this thing against Lil Durk. So, who knows, man? hey, our guy from 63rd, he might have screwed up the process, and Lil Durk might end up going 3. It's a long shot, but let me know what you guys think, man. I will be sure to update you in a month. We will have a response to this paperwork. I'm sure we might get new information. It might get sealed, but the trial is set to happen in January 2026, and I will keep you guys updated all the way. Thanks for watching. Catch you in the next one. Peace.